Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
And then third, as far as specific language, I think I'm going to go to Justice Thomas's point, which is cession, as this court said in Rosebud Sioux, means the surrender of territory or jurisdiction, and here you have the explicit surrender of territory and jurisdiction. The Curtis Act said tribal law shall not be enforced. The allotment agreement said all right, title, and interest is divested. You combine those two things together, that's enough to say that there was no reservation status. But on top of that, you have a bunch of other statutes that do even more things than that make it absolutely clear.
Justice Kagan?
General, if we could go back to this dependent Indian community question, which is a complicated one because, of course, our use of language can change over such an extended period of time. But when I look back at some of these cases that were decided around the same time that Creek Nation was decided, it seems as though the case for Mr. Gershengorn's view, which is that this term was meant to be an umbrella term, is a pretty strong one. And specifically, a case called McGowan, which relied on another case called Pelican, talked about the broad use of the term dependent Indian community and said that whether something was a reservation or a colony was irrelevant because both were dependent Indian communities. And then Felix Cohen says in his treatise, speaking of these cases, he says, and I'm quoting here, all Indian reservations are also dependent Indian communities unless they are uninhabited. So could you comment on that?
I think you have to read it as well, taking into account Venati, which says that tribes with their land and fee are unlike Indians living on reservations. I don't think you could read 1151B as just completely the same as what's in 1151A and C. But more than that, a reservation has to be land reserved from sale, and here the land wasn't reserved from sale. It was sold. It was given to the Creek Nation in exchange for their lands in fee simple. So if you
that's a different kind of argument. Excuse me, General. That's a different kind of argument. That's the argument that fee simple is itself inconsistent with reservation status. And aren't there other tribes that also have been given land in fee simple that have been recognized as reservations?
No, and thank you for the opportunity to address that. So the Creek Nation points to the Seneca in New York as having fee simple, but they yielded their land not by cession, but by selling all their right to private parties in 1797 and in 1842. So under their theory, all of western New York and the city of Buffalo is still an Indian reservation, which would be highly disruptive. They also point to the Wyandotte in 1817 treaty, but they neglect to mention the 1818 supplemental treaty that relinquished the right to a patent and instead gave them a reservation. So our position would disrupt no land anywhere. And in 2015, by the way, the Second Circuit looked at the Seneca's restricted fee land in the Buffalo area, and it said, you know what it is? It's a dependent Indian community. Since
Thank
then,
you, Counsel. Justice Gorsuch?
Counsel, I have 4 questions. I'm going to tick them off as fast as I can, and you can choose which ones you want to respond to in the time you have. First, can you explain to me why the fact that the land is in fee simple would lead to a less stringent disestablishment test than solemn? I guess I don't understand why that would be the case. Second, at least in the briefs, you make a lot of later demographics and evidence about what's happened. I guess I'm struggling to think why that should be relevant in an interpretation of statutes from the last century, especially when later demographic evidence sometimes shows nothing more than that states have violated Native American rights, including Oklahoma's, for example, enforcement of its state laws on tribal lands against tribal members in the past. And then third, practical impossibility arguments. if you could address what's wrong with what is in the brief by Robert Henry about how states often work with tribal entities. And then finally, fourth, I would have thought that after Carpenter versus Murphy, we might have seen a tsunami of cases if there were a real problem here that we haven't seen. So any of those you want to take up, feel free.
I'll do my best, Justice Gorsuch. Why does it mean less protection? We're not saying it's less protection or more protection. That is a false paradigm. Congressional intent controls regardless. 1151 is not a sliding scale of protection with reservations or dependent Indian communities being more or less. Now, they did have more rights with respect to the title, which is why Congress decided they needed tribal agreement, but the tribe agreed to divest itself of that title. But when it comes to dependent Indian communities, what you said in Hydro Resources and what Venatai said is that dependent Indian communities, when the land becomes alienable, it's no longer part of the dependent Indian community, and that's based on the text of textual differences between 1151A and 1151B. As far as what happened upon statehood, we're not relying on what happened 100 years after statehood. We're relying upon the tribal understanding, the federal understanding, the understanding of federal judges during the process and as the process was being implemented. Federal judges, at the moment of statehood, transferred cases involving Indians to state courts. And the tribes understood, as we prove in our respondent's appendix, that they would be subject to state law. So what we're talking about here is the original tribal understanding and the original public meaning, and what they are trying to do is impose a modern lawyerly gloss on statutes enacted 100 years ago. So if you look at the original understanding of how everybody implemented it, it is completely as Oklahoma is doing today. The fact that there's no tsunami, we've had 178 people already seek relief under Murphy, even though the Murphy mandate has been stayed and the Oklahoma Court of Criminal Appeals decision is still binding on state courts. So that 178 cases are just the initial cracks in the dam, and that doesn't even include the state court filings that our office isn't notified of. So I don't think that you can say that there's no tsunami coming. And then as far as practical things, yes, we're going to try to work with the tribes as much as we can, regardless of how this decision comes out. We work with the tribes on a day-to-day basis in doing a lot of great things in the state of Oklahoma, but that doesn't stick with the retroactive.
Justice Kavanaugh? Thank you, Chief Justice, and good morning, General. I want to pick up on your comment earlier that Congress made clear that Indians and non-Indians were to be treated alike, and to pick up on Justice Gorsuch's reference to demographics and follow up on what I said in my earlier questions. My understanding is that as of 1890, this was a very unusual situation because it was already predominantly non-Indian in Indian territory. And that put Congress in a very difficult position of figuring out what to do. And I think that it's necessary to understand to figure out what the text of these statutes mean. So I guess my question on demographics is, people talk about the demographics now. The demographics in 1890 were also similar. How should that affect what we're thinking about? And more particularly, can you connect that up to the text of the statutes that Congress enacted in that 17-year period to transition to statehood?
Certainly, Justice Kavanaugh, and I think that's the right way to look at it. By statehood, 90% of the area was non-Indian. And I think what that means is that you have to figure out what Congress was trying to do, which is abundantly clear from the history, which is Congress is trying to undo the tribe's exclusive ownership of the land and exclusive governance of the land, because there was no territorial government, to give it to a new state that would govern the land, non-Indians and Indians alike, and where non-Indians and Indians alike would own the land. That is nothing like any of this court's previous cases. Mr. Gershengorn was not able to point to any case that was anything like that. And so how that connects to the statutes? Well, if what Congress is trying to do, and this is very clear from the history, Congress was trying to transform both the jurisdiction and the territory and the land ownership. Well, the Curtis Act transformed jurisdiction. It says tribal law shall not be enforced. And the allotment agreement transformed their land tenure. Now, the other side says, well, we could still levy taxes. Taxes were affirmatively abolished in the Five Tribes Act, so they can point to no actual tribal power that existed. The one power they can appoint to was abolished in the Five Tribes Act.
Thank you, counsel. Deputy General Needler.
Thank you, Mr. Chief Justice, and may it please the Court. In preparing the Indian Territory for statehood, Congress eliminated all the hallmarks of a reservation. Congress broke up the tribe's national domain and extinguished the tribe's interest in it. Congress likewise eliminated the tribe's territorial sovereignty over that area by abolishing tribal courts and prohibiting enforcement of tribal law in territorial courts. At the same time, Congress eliminated the distinct treatment of Indians under federal law. It instead subjected all persons in the territory, irrespective of race, to the same courts and body of law, largely incorporated from the state law of Arkansas. And Congress carried forward that framework for the new state. It directed that Oklahoma law would apply throughout the former Indian Territory and provided for the transfer of criminal and civil cases involving Indians and non-Indians alike to state court. Congress did not then radically change course and imposed a reservation-based jurisdictional regime throughout eastern Oklahoma upon statehood.
Mr. Needler, the Creek land was owned by the tribe in communal fee, unlike the situation on most reservations. Could you explain the consequence of that for the analysis in this case?
Yeah, I think it's significant, and I think it strongly supports this establishment here. The tribe had fee ownership as part of setting aside the territory for its nation to be undisturbed, and the treaties provided that no territory or state would be created there. So after all the non-Indians moved onto the territory, Congress concluded that was untenable, and it had to break up the nation, and that included both the fee and the sovereignty. And so when Congress provided for allotment, the tribe specifically ceded its interest in the land, conveyed its interest in the land to the individuals. And because the fee was the hallmark of their sovereignty, what made them separate, the tribe's own conveyance of the fee to individual members and extinguishment of all interest in it extinguished their sovereignty at the same time.
Thank you, counsel. Justice Thomas?
Yes, thank you. Mr. Needler, in Solem and Parker, we had clear reservations, and it was pretty standard. And then you had an effort to dispose of or to alienate surplus land. Here, this is entirely different. Have you seen a case like this in which we have applied the Solomon Parker framework?
I have not, and the point you made earlier that Congress, in all those earlier cases, the court was really trying to discern the consequence of a surplus land act standing alone. Here, you have other statutes that specifically address those consequences. Each of those cases arose in deciding whether federal law would apply or state law would apply. Here, Congress answered that question directly. There's no need to infer that from the Surplus Lands Act alone. Congress, in preparation for statehood, provided that the same laws would apply to Indians and non-Indians, and then turned over a territory with those attributes to the new state. And immediately upon statehood, when that compact of statehood was entered into, the state courts started to exercise jurisdiction over Indians in that territory in fulfillment of Congress's preparation. And that was done pursuant to an act of Congress. It's not simply a consequence of surplus lands. All of that is the consequence of Congress's preparation for statehood.
Thank you.
Justice Ginsburg?
What about statements that an allotment conveying the title and interest of the tribe, an allotment, unlike cession, doesn't diminish a reservation?
There's no a priori test for that proposition. The important point here is that when Congress started the move towards statehood, the preparation for statehood, it did that in the Dawes Act in 1893, and that act provided that for the Dawes Commission to negotiate for cession, for allotment, or such other method that could be accomplished in preparation for statehood. Congress regarded whatever method could be worked out as the prelude to statehood, and the reason for prelude to statehood is because Congress was preparing to substitute the state for a territory, just as it has done with all territories in the past. The only difference here was that there was no territorial government separately established. It was the territories and the governments of the tribes, which Congress essentially prevented from enforcing their laws and created a situation where the land with that characteristic could then be transferred to the state with Indians and non-Indians treated alike.
I think this question has been asked before, but when the tribe, not the United States, the tribe, holds title to treaty-guaranteed land, you say we should apply a less stringent standard for disestablishment. Why? I would think that you anticipate an even stronger showing when it is the tribe itself, not the United States.
I'm not saying it's a less standard. It's a less stringent standard. What I'm saying is that what Congress did needs to be understood in the historical framework in which it acted, and the framework that was understood by everybody concerned at the time of statehood. The compact of statehood that provided for this, it wasn't conferring jurisdiction on the state. It was part of the compact under which the state came into the Union, that in eastern Oklahoma, as was prepared for it by Congress, Indians and non-Indians were treated alike. That was the deal, and that was followed through with by transferring cases involving non-Indians. And the fact...
Thank you. If we decide that Solem doesn't apply here, or there's an exception, then you would win, I assume. Let's assume that. But would that not cause the same practical problems elsewhere in the country? For 35 years, people have lived under Solem. If we change it or make exceptions, won't there be places where people bring lawsuits of people who are in prison and they say we were tried in the wrong court? The same circumstances here. We thought we were a tribe, and the prisoner says, no, you're not a tribe, and vice versa. So why does the parade of horribles work in only one direction? Departing from Solem, you get the horribles. Regardless.
We think this is a compelling case under Solem, but also that the court has to consider the application of Solem with respect to the unique history of Oklahoma. There is no other territory of the United States converted to statehood.
That isn't quite my question. My question is, if we make an exception from Solem, or if we change Solem, is there not likely to be the same kind of parade of horribles elsewhere? I don't know the history of every tribe in the United States, and though you know a great deal about it, I'm not sure that you do.
I'm sorry.
No, go ahead. You see the point.
If you created an exception to Solem, it would be an exception that would no doubt be based on the unique circumstances of this case. Again, unlike in Solem and other cases, there's not just a Surplus Lands Act. You have these other specific statutes directed at the consequences of disestablishment, the attributes of disestablishment. And I'm unaware, and we haven't seen in the 8 or 9 or 10 disestablishment cases this court has had anything resembling that, where where there are separate statutes implementing.
You know what happens, say, in Alaska or in Hawaii or in Wyoming? Have you all looked into this and said if you create an exception and there's no one else who could qualify for that exception?
No one has identified. We have not. Of course, in Alaska, there are no reservations at all. In Wyoming, there's one reservation. So nothing like this has surfaced. And again, this has been the case for 100 years in Oklahoma, more than 100 years, since Oklahoma entered the Union on the understanding that Indians and non-Indians would be treated alike in the eastern half of that new state. There's nothing like that.
Mr. Needler, the broad question whether the Creek Nation has a reservation or whether it's a dependent Indian community has all sorts of implications. But what I'd like you to address is whether we can decide this case on a narrow ground, because after all, the only thing that's involved here is a criminal prosecution. So if we were to look at the narrow question whether Congress has provided for the trial of cases like this one in state court, what would an opinion like that look like? What would it look to? The 1897 Act, the 1906 Enabling Act, and the amendment in 1907, the way these laws have been interpreted for 100 years, what would an opinion like that look like?
I think it would look at all those things. And again, what happened prior to statehood is highly relevant because everything Congress did was in preparation for statehood. So the subjecting Indians and non-Indians to the same laws was part of the package that Congress incorporated into the new state at statehood. So the 1897 and 1904 acts are critical, and the Statehood Act, which provided for the transfer of cases to state jurisdiction, was contemporaneously construed and applied by those responsible for implementing it.
Well, what would you say to the argument that we shouldn't look to the way it was interpreted right after statehood or for many decades after that, because those people were proceeding in bad faith? The statutes were clear, and the state was simply usurping authority, and the federal government was going along with it.
There's absolutely no basis for that. These are federal judges, federal district judges, federal Indian court judges, and state court judges, and state court prosecutors. Everybody on the ground understood that. There was a case in this court called Hendricks, which proceeded on the assumption that an Indian in the Indian Territory had committed a crime. His case should have been transferred to state court. There was some special statute that said otherwise, but the premise of the whole case was that his case would have otherwise gone to state court in Oklahoma. And it's important to understand that the tribe understood that, and I urge the court to look at the statements by the principal chief of the Creek Nation in 1906 after the Five Tribes Act was passed. And he said, upon the establishment of a state government, all powers over the governing even of our landed property will cease, except insofar as the distribution of our property and money is concerned, which will be entirely...
Justice Sotomayor? Mr. Needler, I understood that statement was in light of the existing congressional disestablishment legislation that Congress subsequently changed and didn't go through it. But putting that aside, I haven't figured out whether you've accepted the Oklahoma's suggestion about the dependent Indian community exception or argument. Are you endorsing that argument?
No, not in terms. We're not. I mean, this court has discussed dependent Indian community separately, but some of what informs the state's argument we think is very important, as I said before. That the
state. But let's go back to: is there a consequence that we're unaware of if we were to describe this creek land as dependent Indian community? What other things would we You're saying the things that inform that discussion inform your disestablishment. I understand your argument, but why aren't you endorsing the dependent Indian community argument?
Well, there could be other situations. I mean, for example, in Oklahoma, Congress has provided for various statutes to apply to tribes within their former reservations. And if these were regarded as dependent Indian communities, would statutes like that apply? Now, Congress still refers to them as former reservations. But one point that I think is that makes the dependent...
I hate to cut you off, but I do have one last question here, which is, what do we do if we say this reservation was disestablished? Under what theory would we recognize Indian sovereignty over lands they kept? It was either disestablished or not. And why would all the complex laws that exist now giving the Indians the reservation, the casino rights, and jurisdiction over lands that they own, and all of those other things, what would be the basis of keeping all of that?
Well, it's
told it was disenfranchised.
It's commonplace that when a reservation is disestablished, those parcels that remain as allotments or tribal trust land or of the sort remain Indian country. And so saying the reservation was disestablished, which has been the assumption for over 100 years, would not change anything on the ground, because and Oklahoma has always been understood that allotments are the fulcrum of tribal and individual activities.
Thank you, Mr. Kneedler. Justice Kagan?
Mr. Kneedler, I understand you want to support Oklahoma's position in this case, but just to follow up on Justice Sotomayor's questions about what dependent Indian communities were or were thought to be in 1935, do you think that those concepts were mutually exclusive, a reservation and a dependent Indian community?
No, I think there was a lot of overlap, and sort of the bottom. The court often described them in general terms as land validly set apart for the use of Indians as such under the superintendents of the government, and that phrase appeared in Potawatomi in describing is there a difference between trusts and reservations. So the same general concept is there, except for a reservation, as opposed to an allotment, for example. It's owned collectively, and so when the land is broken up, as it was here, particularly when it's fee land that is broken up, and when someone conveys their interest in fee to somebody else, they are conveying all of their interest in it. It's not like trust property on the typical reservation where when it's allotted, the United States retains an interest and therefore on behalf of the tribe in some sense retains an interest. When it's fee land, it is conveyed out of the tribe and the tribe loses all of its interest in the land. And that's particularly clear under this allotment agreement because it provides that the United States also extinguished, by approving the deeds, extinguished its interest in the land. And that interest was a reversionary interest for when the tribe was disappearing. And so by relinquishing the United States' interest in that land at the same time